See Ms. Brenner.
You know what? Because I told her that they were bringing him on at 1:45.
We're all set, Your Honor.
No, Ms. Brenner. I need Ms. Brenner.
I can email her.
Okay.
Do you see
Good.
Mr. Davis? That's my other client, Caruth Davis.
I do. We can take care of him.
Okay.
There's no change in his status. We haven't received any. Ms. Newland.
Yes.
251222 FY, People State of Michigan versus Caruth Gordon Davis Jr. Appearance to the record.
Good afternoon, Your Honor. Laura Kamash on behalf of the people.
Good afternoon, Your Honor. Paulette Michelle Lofton on behalf of Mr. Davis. Mr. Davis, are you able to unmute yourself? It should look like a microphone with a red line through it.
Always.
Yes, it was.
Okay, if you could, in and out of,
Just turn your camera on. Unmute. Unmute. Sir.
Mr. Davis, we still can't hear you. It looks like a microphone at the bottom. Should have a line through it. You're going to want to click on that. You have to join audio.
I just don't be understanding how people don't know how to do Zoom and they're not next to someone who knows how to do it.
Zoom, yes. Nope, still can't hear you. Is your daughter there to help you?
We'll try again. I'm gonna kick you out, come back in. Maybe it. So we'll go out correctly now.
Joined for Mr. McCrary now. Miss Brenner emailed me.
did they send you a breakout room?
And then Miss Abramson should be in the room as well. She's also assisting me on this.
All right, this is case number 241392 FY, 241393 FY. These are the people state of Michigan versus Darius McCrary. Appearance for record.
Good afternoon, Your Honor. Sarah Brenner, Assistant Attorney General for the people.
Good afternoon, Your Honor. Paulette Michelle Lofton on behalf of Mr. McCrary.
Good afternoon, Your Honor. Lindsay Abramson on behalf of Mr. McCrary.
Mr. McCrary, good afternoon. State your name for the record.
Afternoon, Your Honor. McCrary.
So I have two waivers here on both cases. So Mr. McCrary, please raise your right hand.
And Your Honor, he will be affirming to tell the truth due to his beliefs.
That's fine. Do you swear or affirm, subject to the pains and penalties of perjury, testimony you give this court will be the truth, the whole truth, and nothing but the truth, sir?
Affirm.
Put your right hand down. You do have a right to a preliminary examination in both cases. Do you understand?
I do.
Examine the complaint and witnesses in support of the prosecution under oath in my presence in both exams. Do you understand?
I do.
It's the prosecution's burden of proving probable cause. These two felony charges were committed in the city of Pontiac and were the individual that committed them. Do you understand?
I do.
And at the exam, you do have the right to testify, offer evidence, have your attorney examine and cross-examine all witnesses. Do you understand?
I do.
And at the end of the exam, if I find that prosecution has not met the burden of probable cause that these two crimes were committed in the city of Pontiac and you were the individual that committed them, I can dismiss the charges or reduce them to misdemeanors if possible. Do you understand?
Yes, I do.
By waiving the exam, you'll be bound over as charged with Sixth Circuit Court to potentially stand trial. Do you understand?
Yes, sir.
I'm pretty sure there will be a bond argument, but until that's made, your bond and the conditions will remain the same until amended or modified by a Sixth Circuit Court judge. You understand?
Yes, sir.
After speaking with your attorneys, Ms. Lofton and Ms. Abramson, is it your informed decision to unconditionally waive these exams in both cases and be bound over the Circuit Court?
It is.
Waiver of these exams is not subject to reversal or appeal after today. Do you understand?
I do.
Is anyone promising you anything, threatening you, or forcing you to waive these two exams?
No, sir.
And you're waiving both exams knowingly, intelligently, and voluntarily. You understand the consequences of what you're doing?
I do.
Mr. Brandon, Brenner on behalf of the people.
Your Honor, the people also waive their right to the exams.
All right, I find that Mr. McCrary has waived his right to examine both cases knowingly, intelligently, and voluntarily. He understood the consequences of doing so. Has not disclosed anyone on this record threatening him, promising him, or forcing him to waive his right to have his preliminary examination of both cases. So you're bound over. Therefore, you're bound over to Sixth Circuit Court as charged in both cases. Your arraignment date will be 7 to 10 days from today, but they'll reach out to the public defender's office and you will let you know that date. All right. So, if I continue, are we making a bond argument or we're all set?
No, Your Honor, if I may make the argument.
You may.
Thank you, Your Honor. We believe, as we have communicated, not directly through you, but through your division, I let your division know on, I believe, Monday, that we believe that the order issued by this honorable court a week ago, with all due respect, was not a lawful order because it did not give Mr. McCrary a bond, which he is legally entitled to under the Eighth Amendment, as well as Michigan law, MCR 6.106B1, which the prosecutor agrees with this argument that the court must set a bond. In this case, he does not qualify for a no bond due to it's not a murder, it's not criminal sexual conduct or anything like that. And the only case he would be eligible for no bond would be the case in Judge O'Brien. The court can revoke a bond, of course, as the court knows, when someone is on release and violates that bond. But this is a new case, a nonviolent charge that does not meet anything like this in the statute, and he must, by right, have a bond. Now, the issue of what the bond should be is, of course, for the courts, but we believe, even if the court, we believe the court must give him a bond under the law, but he's also entitled under the Eighth Amendment and the applicable Michigan law, People versus Gia Cologne, that's 16 Mishap 352, that Mr. McCrary is entitled to a reasonable bail. And the Eighth Amendment prohibits bail being set so high as to function as a denial of bond altogether. Mr. McCrary is already being held, and I know some of this is repetitive, and I'm sorry for that, but he's already being held on.
Yeah, I understand that. I just want you to get to your argument. No disrespect, but I understand he's being held in $118,000 out of circuit.
Right, and I just felt the need to that I have to say that again, because if he's given an even higher bond, we don't think the bond should be any higher than what he owes. That would serve as essentially a conviction before trial, and the whole purpose of these cases are to have him pay child support. So we are asking again for $5,000, no 10%, and do not believe the court can enter a no bond order. Thank you.
Ms. Brenner.
Your Honor, after having a chance to look more into the statutes, I think that that's accurate, that the no bond doesn't apply in this type of case. I would ask again that you set a bond. I had suggested last time $250,000 cash surety. I think that that would be reasonable to make sure that he, if he bonds out, that he has reason to return, unlike last time.
Okay. So I believe there's what's the cost for the tether? Because there was a tether on him, and then when they pick up, he don't have it, so he's liable for that. What was in the $112,000 bond? More specifically, was the extradition cost in part, because I'm going to apply that one. If it wasn't in O'Brien's case, I'm going to put that on this case because we have to go get him. Taxpayers in this state have to go get him.
Yes.
So if those two questions can be answered, that could be his bond, appropriately cash.
The bond is approximately $15,000 for the two files. It was $7,000 on one and about $7,800 on the other. Judge O'Brien did not tell us the numbers he was factoring in. He did ask me that same question about extradition, so I'm assuming he factored it in, Your Honor, but I can't tell you for sure. I know he went by the amount of the arrearages, which is, just over 82, and somehow we landed at like 112, but he didn't tell us how.
So I grant the motion. I'll set it at 25,000 cash.
Thank you, Your Honor. And just to be clear, because I noticed, I checked the Clemis website before I signed in. The jail already has it a bit wrong. They're showing the absconding bond to still be $100 and no bond on the child support case in front of you, just so you're aware.
Okay.
I just want to make sure it's on the right case numbers.
The child support should be 18,868.32 posted in his name. I don't know why that's denied. I never denied that one.
Right. I just wanted to let you know
right.
what the website shows.
I don't know. I can only control how 50th District updates his record. So yeah, if there's any questions, my file is the most accurate. All right, so we're all set. His bond 25,000 cash, no 10%, no surety.
Thank
Thank
you,
you.
Judge.
Thank you so much, Your Honor.
Your Honor, I have another one set with you, but it's